Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk After Dark, our Tuesday night live show. We always have something to talk about. I want to thank everyone for joining us this evening. Obviously, the case that seems to be garnering a lot of attention lately was the case out of Colorado here of the truck driver, Rogel Aguilera Medeiros. 110-year sentence for the deaths of 4 people, as well as multiple people injured. And a lot of people are upset, saying this was just an accident and nobody could have prevented it. I'm not sure I necessarily agree with that particular statement, but 110 years is a long time. When you're 23 years old, that is a life sentence. Even under our sentencing scheme that we have here in the state of Colorado, most of these charges that this young man was sentenced for require 75% of that sentence to be served before he would be eligible for parole. Do the math. 75% of 100 is 75 years plus another 10. That is another 7. So 7 plus 77 years till you're, in theory, supposed to be eligible for parole. The reality of it is he'd probably be eligible for parole about 50%. So he still would be a very old man. Now, for those of you who are not familiar with this case, you may want to check out the video that we put up today. We were talking about this case, and clearly it's a tragedy because there's 4 people that were killed, others that were severely injured. Then we have Rogel Aguilera Medeiros, who is 23. I think he was 22 at the time. He had no criminal history, no bad driving whatsoever. But it was alleged that he was driving this tractor trailer, some 85 miles an hour when the brakes failed. That's what he told the investigators. He's cooperated throughout the investigation. He also said that he tried to pull over to the shoulder to avoid the stopped traffic, but another semi had already stopped there. That was according to the arrest affidavit. Well, this resulted in a fiery 28-car pileup, like I said, that killed 4 people. The people that were killed, 24-year-old Miguel Angel Llamas Arellano, 67-year-old William Bailey, 61-year-old Doyle Harrison, and 69-year-old Stanley Politano, Politano. Now, as probably can be expected, and I'm sure a lot of people if it was their relatives, the relatives of the victim said, hey, he should serve the sentence for the crimes. The family obviously believes that this was preventable. There were issues regarding the safety of this vehicle, and it's alleged that he kind of went down the hill knowing the brakes weren't great, but, maybe a little confident. And I think I misspoke. 26 years old. But he was found guilty of vehicular homicide and 23 other charges. So he's 26-year-old. He got sentenced. And, this is a case where a lot of people are going to be upset no matter what happens in this particular case. Obviously, the family thinks that 110 years is appropriate. It's their loved one. And this wasn't just, they were in an accident and, it's a terrible, tragic thing. It was pretty gruesome. Most of them burned to death in their cars because of the accident. Now, obviously, our young semi-driver stated at sentencing he wished that he had done something and maybe even taken his own life. But, that's at sentencing. Now, the sentencing judge, who was actually a judge from Denver that was sent up to Jefferson County to handle this matter. Not exactly sure why that was, but he even stated that a lesser punishment was warranted, but that the mandatory minimum sentencing laws required that the sentence for the 27 counts of vehicular assault, reckless driving, and other charges by statute had to run consecutively, which means one after the other. And the judge stated on the record that if this was his sentence and he had the discretion to do so, that would not be his sentence. Now, the district attorney was not the district attorney when this case was charged, but let's not forget, she was the district attorney when the case went to trial. Now, the district attorney in this particular case, Alexis King, she's a very nice woman. She has, hasn't been in office very long, and she came into office in Jefferson County as a Democrat. And I think Jefferson County is pretty much divided, but it used to be very, very conservative. And I can't recall the last time a Democrat was ever elected up there. Neither here nor there. In my line of work, it doesn't really matter. But, she went in with this whole notion of kind of a kindler, gentler world. And I think it's kind of interesting that, that's what they wanted, and, people are going to have more discretion, what have you. But then when the rubber hits the road, she didn't do anything until there was a bunch of public outcry. This was a very, publicized case, and the district attorney could have said, wow, did we really need to charge those crimes of violence of first-degree assault when we already know that the vehicular homicide statute covers the conduct that's appropriate here? But they allowed it to go forward. And, this is sometimes what happens when you roll the dice, okay? It's my understanding there was an offer by the district attorney that they thought was an appropriate sentence in this particular case, which was 20 years in the Department of Corrections. The defense apparently said, no way, we're not taking that. He'll take a traffic offense, stating that the driver was not responsible in any way. He should be allowed to basically go free. His brakes failed. If this was anybody else, it wouldn't have happened. Obviously, like I said, he gets convicted. He rolls the dice. Okay, and I assure you, ladies and gentlemen, this is a defense attorney's worst nightmares. Okay, you have what would appear to be, some people may think 20 years is even too long. Any time is too long. But then you're looking at a minimum of 120 years. And I'm assuming Jim Colgan, who hasn't been a defense attorney long, when I say long, a couple of years. He was a prosecutor for many, many years. I've known Jim Colgan for a long time. It was, professional. We've had cases together over the years. Our daughters used to dance at the same ballet dance studio. And, he's a good attorney, and maybe he thought, hey, we could do this, we can win this. This wasn't your fault. Let's go forward. But you always have to tell the client, but here's the worst case scenario. Worst case scenario, if you're found guilty of everything, you're going to get 110 years minimum. And there's nothing anybody can do about it. Okay? And normally when this situation happens, there's not a big outcry. There is simply okay, next case. That's it. Obviously, in this particular case, Mr. Aguilera Medeiros has a lot of friends. In fact, he has, as of right now, about 4.1 million friends, and they're trying to get 6 million friends so that this petition for some sort of clemency will go to our governor here, Governor Jared Polis, and grant some sort of clemency. Okay, clemency goes back to the days of the king. You could be found guilty, but the judge could exercise their discretion. They could give you a pardon. They could reduce the sentence, kind of give you credit time served if they didn't give you a complete pardon. It's kind of clemency is the power of the king. It's an awesome responsibility. Some presidents are very generous with it, whether you're governor or president. Usually they're more generous with it when they're going out of office. So if there's any flack about it, you'll just have to, so they don't have to worry about it, the political uproar. Now, this could be tricky for Governor Polis because let's face it, I think anybody that knows anything about Colorado politics here, Governor Polis wants to be President Polis someday, and who knows, he may have his shot, but he certainly doesn't want to look like he's going soft on crime or anything like that. So, we'll have to see. What's really interesting is that the prosecution now remember, the prosecution didn't get up and say, Judge, at sentencing, didn't get up and say, this is a really extreme sentence, Judge. We really wish you could do something about it, but our hands are tied. Yeah, they said go along with the minimum because they knew it was ridiculous. So under Colorado law, if you are found guilty of a crime of violence after you go down to the Department of Corrections for at least 120 days, you can ask for a reconsideration on a crime of violence. I've never had one granted, okay? Usually if it's a crime of violence, your guy's going to prison. Your client's going to prison, and that's it. And I assure you, I have never had the district attorney, the elected district attorney, file this. Now, so it's signed by Alexis King, the deputy, and then Trevor Maritsky, who was a prosecutor down in Adams County for 20 years, and then he went to Jefferson County here recently to be with Alexis King there as the deputy DA. Never had the district attorney. I never had a deputy district attorney file a motion for a reconsideration saying the sentence was too harsh on a case where a crime of violence sentence was imposed. And so in this particular motion, it says Alexis King, the DA for the 1st Judicial District, basically requests a hearing pursuant to 18-1.3406(1)A. It says, as Colorado law required the imposition of the sentence in this case, the law also permits the court to reconsider its sentence in an exceptional case involving unusual and extenuating circumstances. The people brought this option to the court's attention at the initial sentencing at 18-1.3406(A), which permits this review after the receipt of a report of the defendant's diagnosis and evaluation. Now that the defendant has been sentenced, the people again request the court to set a hearing as soon as practicable upon receipt of the report. Consistent with the people and the court's obligation under the Victims' Rights Amendment, the people have begun conferring with the victims in this case to obtain and consider their input in advance of the court's hearing and notify them of the date determined by the court. The people intend to file supplemental information prior to the hearing. Okay. Like I said, I'm blown away. Never had a district attorney. But what's interesting here, now all of a sudden, there are unusual and extenuating circumstances. I'm sure all these unusual extenuating circumstances were presented by the defense attorney throughout this case for Mr. Rogel Aguilera Medeiros. And guess what? The district attorney apparently ignored all of those unusual and extenuating circumstances and thought that, it's 110 years a little harsh, Judge, but hey, our hands are tied just like your hands are tied, Judge. So what are we supposed to do? Like I said, I just think that if it was such unusual circumstances, why did the district attorney not consider these unusual and exceptional circumstances? Now, the family apparently wants the whole 110 sentence to be imposed. And under the Victims' Rights Act here in Colorado on a crime of violence or a victims' rights case where anytime there's a victim involved, they have to be notified of any court dates, and they have to be notified of any court proceedings that are going to take place, and they have to be able to state what the victim's positions are to the court so the court makes an informed decision. So it's interesting. They already know the position, and I'm sure it's going to be an interesting conversation because the families, obviously, they have, there's 4 deceased people, others that are injured. They want justice. As far as they're concerned, 110 years is appropriate, right? How do you bring back somebody? I mean, what is the appropriate sentence for somebody that, kills somebody? Obviously, the legislature in the past has tried to say, well, if it's first-degree murder, after deliberation, you basically have no redeeming qualities, and even if you do, it really doesn't matter because you're going to go to prison for the rest of your life. And then they have like second-degree murder, which is, at least here in Colorado, 16 to 48. That's the range. 48 years, basically. If you plead guilty, that's usually what you have to plan on somebody getting for a second-degree murder, right? Then you got reckless manslaughter here, which literally it's a class 4 felony, so it's 2 to 6 years. 2 to 6 years. And then you have criminally negligent homicide, which is a class 5, which is 1 to 3 years. So if you think that this was negligent, maybe, the young lad should have kept his truck maintenance in a little better check. Maybe the trucking company should have taken a little better care of their equipment, etc. Maybe he should have taken that emergency exit ramp. For whatever reason, he did not. You think they could have come up with some sort of plan or some sort of plea. Okay, fine. Let's do 4 counts of criminally negligent homicide. Something along those lines. But people asked me the other day, what were my thoughts on this? And my thoughts were that the prosecutor overcharged it. So I'm not condoning what took place. Clearly, I think there's some fault to go around here to Mr. Medeiros, no doubt. But 110 years, that may, seem a little tough. I don't know. Let me know. If I was his attorney, I'd be outraged, and I'm sure I'd be doing what, Mr. Colgan would be doing if he was trying to get his client out. He's got to look out for his client's best interest and only the interest of his client. The district attorney has something a little bigger to respond to. Her constituents want people to follow the law, make sure the bad guys go away. Maybe there's some deterrent effect. If anyone's ever driven this stretch of I-70, whether you see semis or me, and I'm not going to lie, I've probably sped a little bit coming around one of those corners, but I assure you it may have some deterrent effect to me because as I come down there, I think, wow, I don't want to be going too fast. What if I cause an accident? Well, look what happened to the last guy that got into an accident. 110 years. So, we'll see. This kid's apparently never been in trouble. Young man, no histories of bad driving. The trucking companies had some issues with maintenance and things of that nature. But as I understand the case, that he knew that there were some issues with the brakes, then why didn't you just tell the employer, I can't drive, right? It's not safe. I can't do it. Maybe the employer is going to be upset with that, but I'm sure they probably, the insurance company probably, when they, write that big check for all of these people, they are going to, think, wow, I wish we had just told the guy to get the brakes fixed. Minor inconvenience, some little bit of expense, nothing compared to, the loss of human life, right? And that's what makes it negligent. Is it reasonably foreseeable? Hey, I've got a truck with not great brakes. I'm going to be going down some very steep grade stuff, going down these mountain roads where it's reasonably foreseeable that the brakes are going to go out. Hence the reason all the runaway truck ramps on I-70, right? I don't know. we'll see. Never seen a DA do that before in my life, right? 26 years criminal defense. Never had a DA say, wow, Scott, that case was, your guy just got too much time. Sorry about that. Is there anything I can do for you? Never, ever have I seen the DA join to that. And like I said, if it's so unusual and mitigating circumstances, why didn't they make an offer before? They offered 20 years. He said no. But why didn't you dismiss the cases if you knew it was overcharged? You knew it was overcharged. And this is my gripe, ladies and gentlemen. This is what the prosecutors do. They overcharge cases to, for lack of a better term, beat people into submission to take a deal, to take a plea bargain, because the risk of going to trial is too great, right? This is a vehicular homicide case. This is a careless resulting in death case. It is not a first-degree assault. It is not an attempted first-degree assault case. It is not. The DAs overcharged it, and so if anyone thinks that hey Julie, we did. If there's an injustice taking place and somebody's trying to fix it, it's the DAs, okay? I'm not saying Mr. Medeiros doesn't need some punishment. Like I said, I think there's some fault there. He could have done things a little differently. Not sure 110 years is completely appropriate. And when the DA's now saying, yeah, sorry, don't think 110 years is really appropriate either, they know they're wrong. They overcharged it and they got caught at it, and now they're looking bad. So, if you want to reach out to the DA's office up there, maybe tomorrow morning, let them know, hey, why'd you guys overcharge this case? Clearly he needed some punishment. Probably shouldn't be a CDL driver. I don't know. You can call them 303-271-6800, 6800, 303-271-6800. And, you can ask for Alexis King and say, hey, I'm just a concerned citizen and just curious why you wanted to overcharge that. Or maybe you want to tell her, hey, great job, and, don't reduce that. So, all right. That was our little intro there. Let's see here. We have a super chat. Now, we don't ask for or beg for super chats, but they're always appreciated. And why are they appreciated? Because they highlight in big colors saying, Scott, read me. So we have one here from Peach, super chat. Excited to see you join Nick's panel yesterday, Scott, following Crime Talk since early Watts days. Well, thank you very much, Peach. Appreciate that. And yes, Nick from Rakita Law asked us to come on. It was greatly appreciated. Quite an honor, actually. I mean, his channel is I think 300 and some odd thousand now. It really went up after the Rittenhouse case because he covered it literally from beginning to end. And we were on there to discuss the Kim Potter trial, which is getting, once again, interesting because look at this. Just late this afternoon, let me see if I can find this here. Well, anyway, the jurors came out and said, hey, we've been deliberating for about 13 hours on the Kim Potter case. And for those of you who don't know or recall what the Kim Potter case was, I'll give you a quick facts. Kim Potter was a police officer there in, what was the town? I should know this. Anywhere in Wisconsin. And 26 years in the police force, by all accounts, very responsible police officer, went above and beyond, never had any complaints. Everybody thought she was pretty much a good, solid police officer. Well, there's this stop that takes place with Mr. Dante Wright. They see something dangling from his rearview mirror, and oh my God, we got to pull him over. And I think in the situation, she was a field training officer for a younger police officer. And I think there was also something wrong with the license plates. And listen, if they're pulling somebody over for faulty license plates, not the crime of the century, but it is a crime and it is reasonable suspicion / probable cause to pull somebody over to do that. I get it. If they were just pulling them over for having the little dangly thing in the rearview mirror, that's total BS, okay? Obstructed view. You can't have an obstructed view, right? Total BS. Police officers did that to simply harass people. It's kind of like, having a broken windshield. Years and years ago, they used to pull everybody over. And let's face it, if you came from the wrong part of town or you were of a particular skin tone, you were pulled over for having little dangly things hanging from your car, or you had a cracked windshield. And I always thought it was funny because I remember I was driving a Jaguar at the time. And I remember making an argument. It's like, Judge, my windshield's been cracked all the way across the windshield, completely right in my center of vision. And you know how many times I've been pulled over? 0. Was it because I'm a white guy driving a Jaguar? Probably. Because the police didn't want to mess with me because they figured, hey, I don't know, this guy, he could probably fight back in the sense of go to court, call BS. Somebody else that couldn't. And, they're not looking for drugs. They're probably saying, this guy, look at this guy, probably some square. He probably doesn't have guns and drugs on him, right? So they pull everybody. They pull that over. It's total BS. Anyway, so Dante Wright gets pulled over, a little dangly thing, and not valid plates. They run him. He's got wants and warrants. He's got a warrant for a gun case, what have you. They want him to get out of the car. He's under arrest. He doesn't want to get out of the car. Make a long story short, it's not really that long. But Mr. Wright, kind of resists a little bit. Not the most extreme thing we've ever seen. Basically trying to get the hell out of there, whether by car or, if he could get out by foot. But it doesn't matter. He gets shot right in the chest. Boom! Right there. Hit him in the heart. Heart explodes, dies. Bullet comes out or lodges right over here, right underneath his chest there. So what's the issue, right? Most people think, well, police officers that shoot people shouldn't have been resisting. Well, in this particular case, Kim Potter, officer of 26 years, who attended all the training as it relates to her pistol and her taser, she says, basically, stop resisting, taser, taser, taser. And she thinks she's reaching for her taser, has her taser in her hand. And what does she have in her hand? That's right. She has her firearm in her hand. Ooh, that's why Mr. Wright is obviously now deceased. Bad fact, right? So the question then becomes, was she reckless? Recklessness, right? A reckless disregard for a dangerous situation. You know it's dangerous and you do it anyway, right? Recklessness is kind of like driving down a steep grade highway with a big semi truck with faulty brakes. You know there's a risk and you do it anyway. A conscious disregard for a dangerous situation. So Ms. Potter, now former Officer Potter, because she resigned, I think, the following day. The police chief did it as well. And then all of us, so it's all on body cam video. We've got the video up at some point, don't we, Frank? I think we do. We have the video up, and you can see it. I mean, it's pretty graphic. She's very upset, distraught. She's like, oh, my God, I didn't mean to shoot him. I meant to tase him. Oh, my God. She's literally like, I'm going to prison at some point. And, there's one of the officers there. I think it was Officer Lucky was his name. He's like, but he was trying to get away, Officer Potter. Hint, hint, wink, wink, nudge, nudge, say no more, right? And that was basically the defense argument at the trial, which was, hey, it wasn't recklessness. It was a mistake. It was an accident. It was completely unforeseeable. And, even if it was maybe a little bit negligent, maybe a little bit reckless, She was justified. He was trying to get away, escaping, putting officers in dangerous situation. Who knew what this crazy madman with his little things dangling from the mirror could have done? So she was justified in shooting him. We've talked about this before. One of the unwritten defenses in any sort of homicide case is the dead guy deserved killing, right? And in this particular case, that was kind of what they said. And in this particular case, the Potter attorneys took it to an extreme and basically also said he caused his own death. I mean, it's really his fault. He drove away. He tried to drive away. He crashed, right? So, this is a tough case, right? Just like you got a young kid, truck driver, never in any problems before, looking at 110 years. Or not looking at it, he got 110 years. He got it. It's there. Got 110 years. And then you got another officer, 26 years, impeccable, spotless record, never a complaint, nothing that said she wasn't courteous, kind to anybody in those 26 years. And then all of a sudden, here it is. What do you do? Well, the jury is struggling. They came out and said, hey, we've been deliberating now for about 13 hours. What should we do if we can't reach a decision? And so the judge reread one of their closing instructions, and it's what they call a modified Allen instruction. An Allen instruction is read, and it's based after a case. I think it's U.S. v. Allen. Clearly, the Allen was part of it, but it basically says, hey, don't be afraid to reevaluate what you've thought, look at things different ways, but if you're absolutely convinced one way or the other, you shouldn't necessarily give in, but, give it a shot. Maybe you'll have your mind changed one way or the other. It's called an Allen instruction. Basically says, yeah, go back and try again. We're still working on this. And so the jury went back in. Obviously, we couldn't see the jury. We couldn't tell. We don't get to see what they're thinking, or if they're, traveling in groups, if they're looking at each other, whether it's 11-1 for guilty or 11-1 to not guilty. We don't know. So the judge sent them back. They're going to resume again tomorrow morning. My guess is that they will go back, sleep on it at night, and by midday tomorrow, this is my prediction, midday tomorrow, my prediction is they'll either A, have reached a verdict, or they're going to say that they are hung. And there's no indication whether they're hung on all of the charges, both charges, or whether just one charge, okay? So we'll just have to wait and see what happens. And then the question becomes, what would we do in this particular case? If there's a mistrial because of a hung jury, the prosecution has to decide whether they want to try Miss Potter again. Miss Potter would have to decide whether she wants to go through it. It's my understanding there was no plea negotiations in this case, because some have said that it's somewhat politically motivated, and if it wasn't literally kind of right after the whole George Floyd thing, that maybe Miss Potter wouldn't even be here at all today. I'm not sure I would go that far. I think it was some, they're probably struggling over some negligence. Right? Negligence is negligence. And I have a real problem with a negligence standard in criminal law. Right? In criminal law, it's supposed to be, what did the person do? What was their mental state at the time? Did they knowingly do something? Were they aware of the risk and did it anyway? But when you start getting into negligence is it's a civil thing, right? Negligence, a reasonable foreseeable, but for the cause or the actions of the defendant, this never would have happened, right? I got a real problem with that, because it's what a reasonable person would do, right? You have to impose a duty, and your conduct fell below that of a reasonable person in a similar situation, right? That kind of is the whole problem with when you start getting into negligence for criminal law. I mean, your mental state should be at issue, but they don't do that when it gets to criminal negligence stuff. So I don't know. It's a tough case, and these are the tough cases where, the bottom line is, what's the word I'm looking for? I mean, this is the stuff that prosecutors, judges, and defense attorneys deal with on a daily basis. And you hear about it in these type of cases, a high-profile case of Potter, like, wow, she's a great officer. God, it was a big mistake, but we've got somebody that's passed away. We've got a young kid who, maybe could have done things better. Hindsight, it's always easy to play armchair quarterback, but, he's never been in trouble before. What do we do? I don't know, but he won't take a plea bargain. And I'm telling you, as a defense attorney, there's so many cases where it's like, man, somebody didn't deserve this much time, but the DA wouldn't budge, right? And you've given them all their mitigation. But if you go to trial, your client just doesn't have the guts. And I don't mean that in a bad way, in the sense you got to be brave to go try. They can't do it. Some people can't do it. Some people in a criminal case, they just can't handle the stress. They're like, oh my God, this having the charges. What do I do? Go to court? It's like, listen, if you can't handle this, you can't handle a jury trial. All right. Sometimes you have no choice, and they've got to, make up. They got to just go do it. But these are the kind of cases that go on in the court every day that you don't hear about, that don't make the news, where the defense attorney is saying, hey, my guy's done something, but you're trying to say he did something like and you've overcharged the case. Well, yeah, but my victims are really, really mad, and your guy hasn't accepted responsibility yet. And you're like, what do you mean? I'm telling you, we're willing to take an offer of this, which is more than reasonable. And I'm not saying I know everything, but I've been doing this a little bit longer than the DA that comes up as a county court deputy and has been in district court for 6 months and thinks she's seen the worst of the worst. And it's like, come on. I know you think in county court, every DV and every DUI is the worst case you've ever seen in your life, okay? But now you're in big person court, and where really, really bad things happen, okay? So we need a little perspective. And sometimes I think a lot of people don't get, and that's why attorneys look like we're insensitive people. Like, wow, is that all? I mean, it could have been worse. Let me tell you about this one case that I had, right? That's just nothing compared to that. And that's why people look at attorneys sometimes and say, wow, this is it. What are we doing? So, I don't know. Let me know what you think. Leave me a comment. We'll talk about it here, because I think it's an interesting case. Let's see here. Adder Cobb 47. If Kim Potter would have had the time to check her brakes, she probably wouldn't have pulled the trigger. That's true. But would a reasonable police officer known which one to go to? We had a guest last week on our after-hour show, Mark Carlson. He said, hey, I used to train on that stuff, and it was just, that's why you wore your taser on the other side of your body, so what you didn't grab it by mistake, because the muscle memory, when you reach for your firearm, you're going for it, it's going to be the gun. So, like I said, a lot of people are outraged in the sense that, how could you take away a 110-year sentence? You killed 4 people. I get that. Family members, they're upset. People are like, hey, there's some people that are of the mindset that if you kill somebody, you should go to prison for the rest of your life. You have absolutely no redeeming quality whatsoever. We should not look at the circumstances whatsoever. And, that's it. Just go to prison. And I don't think that's necessarily a good way to do things. Each case is different. I get it. But you know what? Let's face it. If you've got a real crime of violence, right? We have all these mandatory minimum crimes of violence where you lose, you go to you plead guilty, or you go to trial, you're found guilty of the crime of violence, and guess what? You're going to prison. Bottom line. Don't you think, I mean, this makes you just think, right? If this crime is so heinous, a judge who's been appointed by the governor, and then stood election, first after 2 years here in Colorado, and then every 6 years after that, and they've been evaluated and they go through the commission. If they're not sharp enough to figure out what is a DOC sentence, Department of Corrections, and what isn't, right? What's an appropriate sentence? Then why do we even have judges? We don't need them. We just put a little chart together. So the legislature, in our truck driver situation, there's a lot to blame to go around for mandatory minimums. We got, that case. I'm not saying the guy should get off. I think he made some mistakes. 110 years seems pretty steep, okay? Well, I think it's a little offensive. That's just me, okay? I mean, it was a traffic accident. Traffic accidents happen every day. People die in traffic accidents all the time. I've had cases where people have died in traffic accidents and other people have died. They burned to death, right? I actually got one going on right now. And people look at, unfortunately, bad things happen to good people. But it's part of life. So, like I said, it's the type of situation where 110 years, because I guarantee you take that case to half a dozen other jurisdictions, and that defendant maybe gets a felony, maybe he gets a bunch of misdemeanors, maybe he does some jail times, but that's it. So, all right. Clumsy Clairvoyance, Super Chat. Love seeing you on Nick's channel. You're both shining a light on the prosecutor's conduct during recent trials. To me, it's appalling. Yeah, and you would think that prosecutors, their job is to do justice. It's not to get the most number of years, not to get the most numbers of wins so they can tack it up on their board. It's to do justice. And sometimes doing justice is saying, hey, I'm sorry for the loss of your family, and I understand that, the tragic loss. I couldn't imagine losing somebody like that in such a terrible situation. But, a lot of these people were older. I'm not saying that minimize it, but that's, sometimes DAs have to have tough conversations with victims and say, hey, I get it, but I got to look at the bigger picture. And this sends a message to everybody out there. So we'll see. Mama Pink, Super Chat. Shout out to the mods. Jen Lowe, who looks, disappeared. Looks like Jen Lowe is Solonite. Thanks, most dedicated mod out there. Yes, thank you for all our moderators. Be nice to our moderators. They're just doing their best. They really are. No one's trying to censor anybody. We're all about letting people speak the truth. Bottom line is, we want all ideas, even ridiculous, stupid ideas, should be explained. They shouldn't be censored. Why? Because we want those dumb ideas to be out there so people will realize they're dumb ideas, and then we don't have censorship. Censorship is bad, ladies and gentlemen. We've talked about that before. It's just bad. It's bad all around. And people that want to censor somebody's idea and shut them down because they don't like their idea or because it hurts somebody's feelings, that is scary as you put in whatever expletive you want, okay? That is dictator type nonsense. I don't like what you're saying about the king. I don't like what you're saying about this person. That may hurt their feelings, right? We talked about this before. The law doesn't care about your feelings, okay? I was having a conversation with somebody today. Maybe people's feelings need to be hurt just a little bit more often these days so they have a little better sense of reality. I won't go into specifics, but this conversation was, let's just say they have a adult living in their basement that is more than capable but won't seem to go get a job. Cut them off. You can't enable them, right? And I think that's just a product of the time. When I grew up, we lived in pretty modest beginnings. My dad worked in a parts warehouse. My mother was a secretary. There wasn't a whole lot of extras going around for anything. Usually the words I heard were, no, we can't afford it. And I remember I had to chop my daughter down just a little bit, her peg or two, a couple times because she got pretty high and mighty and acted like he was like, well, I'm entitled to this. Like, no, you're not. I mean, don't get me wrong. You've had a pretty good life. I provided a pretty good life. But nowhere is it written that you have to basically start your life as a young, 19, 20-year-old, 21-year-old at the same level that you grew up in. It just doesn't work that way. If it was a graph, you're like, all right, life's pretty good. Oh, you're on your own. Boom, it dips down here, and you got to start working your way back up to where it was. You're not entitled to anything. So, all right, let's get back to some of the questions here. And I think I forgot to say it. Can you believe it already? Could you believe that's already 45 minutes? My goodness. For those of you who don't know me, my name is Scott Reich. I'm a practicing criminal defense attorney here in the great state of Colorado. I do both state and federal work. And, I've been doing primarily criminal defense for 26 years. Had brief time in the Marine Corps as a judge advocate. Prior to that, I was a young enlisted guy, and then finished up school, went to law school, went back in as a judge advocate, got out, started my own practice. Now, can you believe it? January will be 22 years in private practice. I cannot believe that. 22 years. My gosh. Wow, does that make me feel old? But yeah, so let me tell you, these cases where there's like no good result. I had a case once, okay? It still haunts me. Had a case, couple of guys, they're drunk, arguing over something stupid. Usually that's what happens when people are drunk. The other guy picks up a piece of metal, comes out with my guy. There's a knife nearby, basically stabs the guy, reaches in, cuts the 1 in a million shot, hits the guy, hits some artery. I can't remember the name of it. Even the coroner was like, yeah, 1 in a million shot. You couldn't do that again if you tried. Bottom line. Anyway, guy bleeds out, dead. Charged the guy with first-degree murder. Okay? My guy had some issues. He maybe had some prior history, right? I'm a criminal defense attorney. What can I say? I represent people. I represent the people, right? The prosecutors say the people of the state of Colorado. Well, I represent the people of the state of Colorado. I just do it one client at a time, right? Anyway, lunges, literally lunges. And it was a weak case. And if you've ever had a case where the dead guy deserved killing, this was it, right? So you have two guys that have been in trouble. Dead guy, raging alcoholic, drunkard. It is what it is, right? I think he was dating my client's mom or something like that. I don't remember. It doesn't matter. They were fighting. 1 in a million shot. Stabs him in the arm. Bleeds out. And I remember having great news going back. Hey, man. Criminally negligent homicide. He was aggravated, so for 1 to 3, 2 to 6 years. 6 years most, right? And this guy had been in prison, youth, 6 years. He could do that sitting on his head, right? Bottom line, you're like, hey, pretty good deal, man. Pretty good deal. I mean, don't get me wrong. We got a defendable case. The guy's coming out with a big old pipe, right? And it was one of these moments. This was like a Perry Mason moment in court. We're there in court, and the prosecutor's bringing in this pipe. They're bringing in this pipe that they want to show to just get into evidence. I'm like, okay, they're filling time for another witness. I'm like, this is great. And they put the guy up, and he's like, yeah, that's the pipe. I'm like, okay. I'm thinking to myself, I don't have any freaking questions for this guy. Like, okay, he's bringing in the pipe. But I'm like, I got to do something. So I go up and I grab the pipe, dramatic fashion. Investigator, this is a steel pipe, isn't it? Yes, it is. A steel pipe can fit the definition of a deadly weapon, can it, under the statute? Well, yes, it can. And you know that because you've been a sheriff, you've been a cop, and now you're an investigator with the DA's office. You know all that, right? Yes. And I'm standing there at the podium, and I start kind of moving towards him. And I said, if somebody's coming at you with this steel pipe, you'd defend yourself, wouldn't you? And the investigator goes, yeah, I'd probably shoot him. I'm like, I got the steel pipe in my hand. You'd shoot him, wouldn't you? Right? That's what you just said, right? Yep, I'd shoot him. And I'm like, all right, I'm going to set this pipe down right here on the podium so everybody can see the steel pipe. Because that man said he was going to shoot him. He'd shoot me if I come on out with him. I'm thinking case over. The prosecution's witness just made my case of self-defense. Basically testified as an expert witness. It was beautiful. Jury goes back. We come back. First charge. The count of first murder in the first degree, we find the defendant not guilty. I'm like, oh, this is great. This is going to be good. Oh, this is going to be great. To count two, lesser included offenses. And I didn't want lesser included offenses, I would tell you that. The prosecution did. Because I'm thinking, hey, you charge first degree murder. We're going first degree murder. You charge the DAs. You're wimpy. Do it. So they come back. Count two, or the lesser included charge of second degree murder. We find the defendant guilty. Ugh. So you're looking at 16-48, but guess what? They had bitched him. Which means they filed the habitual counts against him. Some states, they call it the 3-strike rule. You got 3 prior felonies, 4th, boom, we'll send you away. So in that case, 6 years, right? 6 years. The DA offered 6 years because they said that was an appropriate sentence to resolve the case. The client said, nope, it was self-defense. I was justified in doing it. Let's go to trial. 96 years on the habitual. Did the DA say, no, sure, we may have offered, the 6. Didn't write a motion for reconsideration like they did up in Jeffco. Nobody got all fired up writing petitions saying, free Scott's client. He was justified. So it just shows you cases like what went up there in Jeffco with the truck driver, Mr. Medeiros, and the Kim Potter stuff. Those kinds of situations, they're not the exception to the rule. That's what takes place every day in a courthouse. Why do you think, I consider myself an old guy. I remember when I was the young guy as a criminal defense attorney. Now I'm like the old guy. And there aren't that many old guys left because it is stressful. You literally have the stress of hopefully convincing your client to make the right decision. And if he doesn't make the right decision, or she make the right decision, that you try to mitigate that loss. And sometimes they listen to you, sometimes they don't. Sometimes they deserve it. All right, you want to roll the dice? I've done many a Gort trial, right? Gort, Gort. That's where the DA comes in and says, yeah, the offer is plead guilty to the original count or all counts, or we'll see you in trial, right? Gort, guilty or trial. They would stamp it on the file there. Guilty or trial. Okay, let's go to trial. I've won some. Sometimes you go tee it up. Let's do it. Okay? But my experience is generally when there's an offer there and the DA's making an offer, that's what they think the case is generally worth. And my guess is the defense attorneys in that case, Mr. Madera's case, were saying, ooh, 20 years, man. 20 years. Non-crime of violence. God, you could be home in like 5 or 6 years. And those are the things that, defense attorneys have to have conversations with their clients. And sometimes it breaks your heart when, things don't turn out. I mean, it's great when you win the trial that nobody thought you could ever win. And, when you're thinking, man, the DA's thinking this, this case is only worth, 1 to 3, maybe 6 years, whatever. I got a shot. And you're like, man, I got some good facts. This is great. Sure, the client, but they're going to focus on the facts. They're not going to, look at his appearance and his tattoos and all that stuff. No. So it's I don't know. It's a tough world out there. It is the type of situation where you can basically, and you don't forget those cases either. It's just what you do. And people are like, oh, the defense attorney. Nah, I mean, you worry about this stuff. You worry about your clients. You want them to make, sometimes your clients have to go to prison. That's just the way it is. The facts are the facts sometimes, and the sentencing scheme is the sentencing scheme. And they're going to have to go to prison. But you want to do your best to make sure that it's the least amount of time if possible. So anyway, let's take a couple more, take a look at a couple of things. I saw a super chat here. I want to go back to it here, see if I can find it. I can't remember where it was. Sometimes they go fast here. Clumsy clairvoyance. Mom told me, I'm not your friend, I'm your mom. That's right. I totally agree with that. Where do those cases come in mostly? Usually where people are giving their kids alcohol, thinking it's okay to go drink, go have fun. That's when we used to do it as a kid. Oh, it's not the same as when we were a kid. Back when we were a kid, people my age, grew up basically in the 80s, so to speak, right? You got in trouble, they drove you home. Now there's no driving you home. Now it's just go to jail. You don't have the discretion. And God forbid, if somebody gets sick or dies, somebody's going to jail. All right? Just remember that. There's a couple simple rules, right? Firearms complicate everything. And usually if there's a dead body, they want somebody to go to jail and or prison. That's just the general rule. There's a lot of other general rules out there, like it ain't legal until the, government gets their cut, things like that. We were talking about that on the Rakita show the other day. They were talking about marijuana, and they asked about Colorado. I'm like, oh, they got marijuana at every corner here. And, the big problem they have is there's so much of it that it goes out the back door. And then the state finds out that they didn't pay the tax on the stuff that went out the back door out to another state. And they're not really concerned that much that stuff was going to the other states. They're more concerned about that they didn't get their tax money. And that's what they want. Because ain't nothing legal till the government gets their cut, right? All right, let's take a look at a couple of those things. And you guys should start eating. I mean, I'm talking. You guys should start eating while it's before it gets too cold. Seriously. We were in pizza tonight for the CrimeTalk crew. And the pizza was delivered, and Julie and Frank, the hardest working people in show business, are sitting there, and I can smell it, and I want a piece of pizza, but I got to talk. So they should just eat the pizza, for God's sakes. Eat the pizza, right? Depends on what we order. Some weeks it's nothing. Some weeks we've done sushi, we've done subs, you name it. Oh, last week we did barbecue because we had a guest, and he likes barbecue, so we did that. Mama Pink. So wait, after all that proving self-defense, the jury convicted your client, Scott. Yes. What the fuck? Yes. That's exactly what happened. They convicted my client. I'm like, this is great. I mean, I'm literally like, ladies and gentlemen, their own witness got up on the witness stand and said he would shoot it. And he's a police officer, and he knows the law. And somebody comes at you with a deadly weapon, you have a right to defend yourself, and you can use deadly force. And the jury said, yeah, maybe if he was a nice, clean white kid or something like that and didn't look like a gangbanger, yeah, that's what happens. The juries don't always see it the way you see it. But hey, the jury made their decision. But like I said, I didn't get the DA saying, hey, Scott, wow, really sorry. I know I offered that much reduced sentence in this case. If your client were to plead guilty, because I thought that was appropriate. Yeah, let me file that motion to reconsider on a crime of violence. Or let me not go forward on the habitual counts, right? And this is, they don't do that. So it only takes one case. And I say this is good because whether Mr. Medeiros goes to prison for some time or no time or 110 years, it draws attention to what goes on. And I'm telling you, I swear to God, ladies and gentlemen, where does all this nonsense start? It starts in the legislature, all right? So I know most people couldn't tell who their local House of Representative, their state senator is. I'm not talking the ones that go to Washington. We're talking the ones in the state level, okay? They're the ones that come up with this nonsense. And it's usually in reaction to some knee-jerk reaction to something that takes place. Our mandatory minimum laws came into effect in the early 90s. That's when they were having the gang summer of violence. Mandatory minimums for everyone. That'll show them. And this is what you get. So I say it's good. And so remember that next time. Try to elect smart legislators, all right? Don't put in people that, they're next in line. Their family was in the legislature. They must be. No, I'm telling you, a legislator could be, I've talked about this before, just like people go in and everyday people resolve hard issues in jury duty, life and death situations on jury duty. We could randomly select the people in the state House and state Senate, and they could do just as good a job, probably better than a bunch of politicians who have all sold out to somebody and are just, on their next stepping stone up. We've talked about this. Don't get me started. Career politician is the worst thing for both local, state, and federal government. We want people that don't want to be there. They're going to go do their civic duty for a short amount of time, and they come home and they don't become lobbyists, okay? The only people that are despised more than attorneys are lobbyists. And I understand you have a right to petition your government, but as a politician, you shouldn't have a right to profit while you're in office. And I think that they can limit the time that you can make money once you get out of office. That's just me, my humble opinion. Career politicians are going to be the death of our country because they only look out for their best interest, not their constituents, not their, I think as our super chat, I think it was Mama Pink said, you have to say, I'm your senator, I'm your congressman. I'm not your friend. They all want to be your friend. Oh, let me give you this. Let me give you a bunch of free money from somebody else, right? Bottom line. All right. Look at that. That goes by so fast. Can you believe it? Wow. All right. Hope you enjoyed the show. Now, if you're not a Patreon member, you should be, because we're going to go to our Patreon show, and there we're going to do our Magic 8 Ball. And on top of that, we're going to take calls. So if you'd like to talk about what we've talked about or anything you want to talk about, because, hey, you're a Patreon member, it's your show, we'll talk about what you want to talk about. So thanks for watching. We'll see you next time on Crime Talk.